My lord, I beg to mention item 15. 15, 1-5. Although this is for orders, Lordship, the copy of the IA, I am for the respondent victim. The copy of the IOA has not been furnished to me. So therefore, they may be asked to furnish the IA, of course, and matter be listed on 18, Lordship. IA is for, I think, suspension of sentence.
I am for the appellant, ma'am. Yes, ma'am.
Two. IA 62 of 24 in criminal appeal 18.
I am Doji, ma'am. Yes, ma'am.
Eighteen. 18 is Wednesday. All right.
All right.
May my lordship. My lordship, I had filed one criminal petition. There is inadvertent mistakes are there, so I need to correct the mistakes. So that is why I want to withdraw that particular item number 6. Yes. T Johnny. Johnny. It's a long name. That Johnny Dogum actually. Yes. Highly obliged.
May I, Lordship? Lordship, I beg to mention item number 23. As the leading counsel is out of station, Lordship, the matter may be taken after 2 weeks. Petitioner. Yes. B type audio. Yes, Your Honor. Two weeks, Lordship. Highly obliged.
Your Lordship, I may be allowed to mention item number 10 for an adjournment. Yes, I have taken the consent. An adjournment for today. M. Khambo. Yes. 10.
I am for the petitioner, ma'am.
I'm for the respondent. Yes, yes. Yes, yes. Yes.
I am Doji, ma'am.
After summer break. It may be listed after summer break. Much obliged.
Oh, my lord, item number 9, ma'am. Yes, in fact, my lord, yes, my lord, it is corrected. I am for a petitioner, my lord. Consent has been taken, ma'am. I am Doji, ma'am.
After 2 weeks. Oblige. May Your Lordship, I beg to mention item number 13, Your Lordship. 13, 1-3, Your Lordship. Your Lordship, Your Lordship, I have checked the records, Your Honor. Your Lordship, the service report is yet to be completed. So it may be listed after 3 weeks, Your Lordship. The report is yet to be completed, Your Lordship. Yes, sir. Yes, Your Lordship. Okay.
Morning, my lord. I come with a very limited prayer here in my lord against order dated 5/5/2025, page 92, annexure 4, my lord. My lord, the trial court has already passed an order despite us pleading there. My lord, it's a very simple matter. My lord, what had happened is, my lord, I was present. I was present. We have filed an application also. My lord, annex. My lord, I'll just come to the crux of the matter. In short, my lord, what has happened is there was a project which was commissioned in Arunachal Pradesh. The company which had commissioned the project was by the name of Sterlite Power Transmission. My lord, there were two contesting parties over the rights on the land. They filed a title suit, and since my transmission line was going over the land and I have already paid compensation, so I was also arraigned as a party in that suit. Now, my lord, my grievance is not with that. I'm also there as a party because if any order is passed adverse, it may affect me. So I'm contesting the matter. My lord, during the pendency of that matter, since Sterlite Transmission Limited is a legal entity, my lord, what had happened is a second legal entity was created by the name of Sterlite Grid 5 Limited. Sterlite Grid 5 Limited, a second legal entity was created. Now, my lord, the two legal entities approached the NCLT, Annexure 1, page 17, my lord, under the scheme of the Company Act 230 to 233 for making an arrangement among themselves. Now, my lord, as per the order of the company's NCLT, my lord, dated 5/9/2024, Sterlite Transmission Limited ceased to exist, and all the assets, business, liabilities. My lord, the earlier defendant in the title suit, my lord. My lord, we were defendant number 2 over there. 2, Sterlite. Now, my lord, ceased to exist in view of the order passed by the NCLT, where everything that belonged to Sterlite has gone to, my lord, Sterlite Grid 5 Limited now. So my prayer there is limited. All we are praying is that kindly substitute the name of Sterlite Transmission Limited because it has ceased to exist in view of order of the NCLT tribunal, and put my name into it. And whatever are the legal obligations and whatever is the litigation, I will do it. This is, my lord, I prayed under order 22 rule 10 during the pendency of the suit to change if an entity ceased to exist to implead me into it. I don't pray for. And my lord, my now grade 5, the urgency impeding is that I will be going into, my lord. Both are private respondents, my lord. So, my lord, this petition will not change the nature of the suit or any. It will, all I'm trying to do is to ensure that the suit doesn't get frustrated, my lord, for want of one of the parties because the legal entity ceased to exist. So I come with a very limited prayer, my lord, that Enkhera, my lord. My lord, we filed, my lord. Suit. My lord, suit was filed by, my lord, applicant number, respondent number 1, my lord, herein, Tabaraju. 1, my lord, herein. Suit, my lord. Civil Judge Senior Division, my lord. I was arranged as defendant number 2, my lord. Erstwhile, Sterlite Transmission Limited was defendant number 2. Now I wish to be defendant number 2, my lord. I am not as yet. My lord, erstwhile Sterlite Power Transmission Limited, SPTL for short. My lord, page 62, paragraph 1, my lord. Defendant number 2 is, as on date, it is Sterlite Power Transmission Limited. Transmission Limited. Present petitioner hearing and Sterlite Transmission Limited, we filed a joint application, my lord, before the NCLT, Annexure 1, page 17. It's very clear. Annexure 1, page 17. 17. My lord, para 1, first, my lord, that this is a company scheme petition filed under 320 to 230 to 232 of the Companies Act 2013, seeking for sanction of the scheme of arrangement between Sterlite Transmission Limited, Petitioner Company 1, and Grid 5 Limited, Petitioner Company 2, and the respective shareholders and creditors. My lord, the operative part is at page 35. Page 35, para 17, my lord. If I have my lord's attention, may I read it? Since all the requisite statutory compliances have been fulfilled, the petition in CPCAA 113 MB 2024 filed by petitioner companies is made absolute in terms of prayer clauses of the said company scheme petition. Therefore, the scheme is hereby sanctioned. This bench further orders that, my lord, entry 2, page 36. It shall be binding on the petitioner companies involved in the scheme and all concerned, including their respective shareholders, creditors, and employees. 3. This is what concerns us, my lord. The petitioner company 1, that is Sterlite Transmission Limited, my lord, shall be demerged and the business operation shall be transferred to the petitioner company 2, that is Sterlite Grid 5, my lord, which shall become the resulting company with effect from the appointed date. My lord, entry 1 is the appointed date, 1/1/23, my lord. So, my lord, as on date, Sterlite Transmission Limited does not exist. So we are praying the. My lord, we jointly filed it, my lord. My lord will see at page 17. My lord, we prayed that there should be a scheme of arrangement where Sterlite Power Transmission Limited will cease to exist and all the business will come to Sterlite Grid 5 Limited. That is the petition number 2. My lord, page 17. Mumbai bench. Sterlite Power Transmission Limited. Sterlite Power Transmission. Sterlite Grid 5 Limited. Sterlite Grid 5 Limited. My lord, page 17. My lord, bottom left, the cost title. My lord will see Sterlite Limited. This is the demerged. My lord, if sees the cost title, my lord will see Sterlite Power Transmission Limited is the demerged company in the cost title, and Sterlite Grid 5 Limited is the resulting. My lord, 5/9/2024. My lord, Sterlite was demerged Madam, defendant number 2 in title suit. Title suit 10 of 2023, madam. Title suit number 10 of 2023. 23. No, my lord. He was the petitioner. I became a new entity, taking over all the business of the demerged company. My lord. Demerged, my lord. My lord, page 36, entry 3. Petitioner company, as in Sterlite Grade 5 Limited. My lord, 1/1/2023, the appointed date. 2023. My lord, we filed a substitution application, my lord. My lord, we filed it on 17th of March 2025. 25. My lord, we filed it before the court for the. My lord, first it was fixed on 16/4/25, but the court was on leave. So then it was fixed on 5/5/25. Now the court over there has given the next date of 28/8/25. But my lord, I am looking at an IPO, public offering, my lord. So if this liability, I have to show to my creditors that I am the company who owns liability in this case. So my lord, I am coming forward to on my lord 16/4/25, but court was on leave. My lord, the PO was on leave. 4/25 on leave, my lord. The presiding officer, my lord. As per the order, how the order is. 25, my lord. On a Court of Civil Justice Senior Division. No, my lord, the time was taken by the plaintiff, my lord. My lord, page 92, third class paragraph. Learned counsel for the applicant, plaintiff, has prayed for time to file reply in the IA. Plaintiff minor. Pilot page 64. I apologize. My lord. Pilot page 13, 14. My lord. My lord, the primary urgency, first of all, is that, my lord, Sterlite Transmission Limited has ceased to exist. And a legal entity will cease to exist. If it continues to be a party in the case, it will frustrate the proceedings. Transmission.
Okay. Will frustrate the interest of the applicant. Starlight Power Transmission, sorry, Starlight Grid 5 Limited. Okay, stop. Therefore, pray for
My lord,
interference.
page 13 and 14 is the prayer.
Prays for interference and to direct for early hearing of the IA. Okay,
16 of 2025. ma'am.
IA 16 of 2025. So, it appears that the application was filed only for the substitution of the defendant number 2 by the applicant. There is the defendant number 2, Starlight
Grade 5 limits.
Grid. The Starlight Power Transmission Limited has ceased to exist, and in its place, Starlight Grid 5 Limited has taken over. Okay, Starlight. And since the petitioner has shown some urgency in the matter, as it is any further delay would cause prejudice to the interest of the applicant. This petition is disposed of with a direction to list the matter within a reasonable period of 30 days. Okay?
My lord.
Within a reasonable period of 30 days from the date of receipt of this order. Okay?
My lord, my lord.
Within 30 days from the receipt of this order. And pass order in the IA 16/2025 accordingly, as per, in accordance with the law. Okay?
My lord,
With the above this,
my lord, in view of the NCLT order, if that observation is given, it will solve the whole purpose. May pass an
okay,
order.
urgency shown, okay, in view of the, and in view of the order,
The Honorable Court may dispose of the matter in view of the order of NCLT. my lord.
in view of the NCLT order dated 5/9/2024, the Planet Trial Court shall dispose of the IA number 16/2025 within 30 days from the date of receipt of this order. Okay, a certified copy of this order with the above this civil revision petition stands disposed of. Okay.
Any other question?
Yes.
Met this lawsuit.
Yes.
Lordship, this CRP has been filed challenging the inferior order passed by the learned affiliate court. Civil Judge, Senior Division, Pasigar, on dated 2/6/25. In brief short, my case is lordship. There was a Kavang decision on 15/10/2030. Lordship. Kavang order was passed on 15/10/2030 regarding some disputed net farmland zoomland area. Accordingly, in the said Kavang, the present affiliate has participated, and they have participated in deliberation process also. Their statements also recorded during the Kavang process. Accordingly, thereafter, lordship, the appeal was filed on 21/11/2014. Lordship. There is a delay of 371 days, unexplained delay. While filing the appeal, lordship, the present respondents, they didn't file any IA application seeking the condonation of delay, nor they have made any averments in their appeal for condonation of the delay of 371 days. But
application was initially filed before.
before the deputy commissioner lordship, before
Appeal,
coming
okay.
into force of
Hmm.
this Arunachal Pradesh Civil Court,
Hmm.
it was filed on 21/11/2014. And thereafter, lordship, only on 2024, lordship, by order of deputy commissioner, said appeal was transferred before the appellate court. That order also I have enclosed, lordship, 1/2/2023, passed by the deputy commissioner. So, lordship, may I take you to the first Kavang decision, lordship? Kavang 1510, yes, page number 83, lordship. From 72, the deliberation of
Decided in his whose favor?
lordship.
Kebab was decided in.
Kavang lordship, may I take it to the operative portion? I have copy.
Gaba decided in your favor.
Yes, Lord, in my favor.
Okay, so they file appeal.
They file appeal.
And what is the
Here-
limitation period?
Their first appeal application.
What is the limitation period?
Lordship?
What is the limitation period?
Limitation period is 30 days.
30 days.
30.
So they file after about a year.
Yes, 370.
No connotation petition.
Yes.
Okay, then it was
Then
entertained.
Lordship, yes. And the said appeal was not taken up for 10 years, Lordship. It was filed on 21/11/2014 before Deputy Commissioner under AFR Act because he was the then appellate authority.
In the appeal, any order pass, stay order, etc.
Nothing, Lordship,
And then-
nothing.
Oh, this, regarding the property
Yes,
dispute,
Jumlin,
the property is under whose possession?
my possession, Lordship.
In your possession.
Yes. Even before Kabang also, Lordship, I have LPC, everything was there. On that basis,
Okay.
Kabang was decided in
Then
my.
while after the matter, the appeal was transferred to the learned civil judge, the
Yes,
appellate court, then what did the learned civil judge do?
Thereafter, Lordship, after transferring it before the learned civil judge, they respondent appear and they file misapplication for amendment of the application, appeal application, because they need some to change some apartments, some name of the parties are to be incorporated. Accordingly, before issuing notice also, it was allowed. They have amended, and most surprisingly,
In the
Lordship,
amendment also, the regarding the limitation.
limit nothing, Lordship,
Okay.
nothing, no amendments regarding the delay.
Okay, whether you have raised the question of
Yes,
limitation.
Lordship. Thereafter, Lordship, what happened? Again, on 6th, it was listed before the appellate court where they have stayed the Kabang decision, ex parte. The Kabang decision which was passed-
Stayed when?
it was, Lordship, stay order was passed on 6/5/2024. Page number 175.
2024.
24. After
They
10
made a
years.
prayer for stay,
Yes,
separate the application?
yes, separate IA application was filed.
You
But
were
it
given,
was not issued
you
to-
were given opportunity
No,
to
Lordship,
object?
absolutely no.
Okay,
After amendment, after granting of stay order, after 10 years of Kabang decision, thereafter only notice was served to me, Lordship.
okay.
Stay order was passed on Lordship 6/5/2024, page 175. 175. Six five.
Where is the order whereby it reflects that the matter has been received, being transferred from the court of deputy commissioner?
Lordship.
What is the first order?
Yes, Lordship. Transfer order of deputy commissioner is Lordship. Order is at 91, page number 91, Lordship. 91. This case was put up before the appellate authority, deputy commissioner, in the year 2023 only, Lordship.
This was 23.
Case records put up today. Now, after the enactment of Arunachal Pradesh Civil Code Act 2021, the deputy commissioner had no more jurisdiction to trial appeal cases. Hence, matter may be
Okay,
transmitted.
this
to-
was endorsed.
Yes. Court of District Judge Pasigat in compliance to subsection 3 of the section 15 of Arunachal Pradesh Civil Code Act. By this order only, they transmitted the case record to the before the civil. Now thereafter, Lordship, stay order is at 175, Lordship. Without opportunity, miscase was
This is
disposed,
in the same number.
Lordship.
Oh, miscase was filed.
Miscase was filed.
And in the miscase, no opportunity, no notice was issued.
Nothing, Lordship. Without hearing me, Lordship, the 10 years old Kabang decision has been stayed. And thereafter only,
Just a minute, huh?
okay,
Appeal of the statement. Okay. Okay, so in their appeal, there was a prayer.
yes. Then Lordship, the very next,
Just a minute. After that, in the deputy commissioner, whether you put appeared in the appeal,
yes, Lordship,
so that appearance record is there already.
yes.
Where do I find?
at Lordship, page number 117. 176 is the first notice, Lordship. After granting stay order, I have received the notice from the affiliate.
117.
Yes, 176 is the notice, and then 176 on 26/6/24. I appeared.
No, no, no. 2020, no, I'm asking about, before here, they have no given any notice, probably, because saying that there is, although there is a prayer in the appeal.
Yes.
So now, my question is whether, did you appear before the deputy commissioner
No,
in the appeal? Never.
Before Deputy Commissioner,
It was
even
just line pending.
line.
Okay,
No
without
notice,
proceeding.
even no notice was issued,
Mm.
even no hearing for the stay, anything was done. After filing, they get just put it in the office.
State suspended. No, thereafter, I think probably after 10 years, so many development must have been taking place.
Yes, Lordship, exactly. I have developed the entire land. I have planted.
Now, now it has been stayed.
Yes, rubber trees, everything, Lordship. Now, hereafter, Lordship, I have filed a written statement, reply, and raising the preliminary objection.
In the appeal.
Yes, in appeal, before the affiliate court. My application, written statement application reply is at 185. And I have raised regarding preliminary objection regarding non-maintainability of the appeal on being barred by the limitation.
So before this, the present court only you filed this application.
Yes, no.
Okay.
Because I have received summon only on 6/5/24. First summon.
Okay. By this impugn order, your application has been rejected.
Not exactly rejected, but Lordship, yes, I have raised a.
Where is the, where is the operative portion?
Yes, operative person, Lordship. Impugn order, page 34. From para 1 to para, Lordship. '22, it's nothing but only copy paste from the petition of both the parties. Then page 40, Lordship, operative person.
Hmm.
Just before coming to this, Lordship, may I take you to the one document, Lordship, or at last page, page 214, annexure 20. 214.
214.
214. Since the last order, on receipt of my written statement and my objection, preliminary objection, the issues were framed.
Yes.
Only one issue were framed because it was only on law point. Today, Lordship, it was passed on 21/10/24. Today, fixed for hearing on preliminary objection. Learned counsel so and so, applicant is present. Counsel Mr. So and so for the respondent is present. Had both the counsel at length on their respective argument, and the following preliminary issue is framed whether the appeal is barred by the law of limitation.
Okay.
This is the
So-
objection raised by me, Lord.
Your application was disposed of,
Yes, Lordship, by this impugn
whether
order.
rejected or what?
Not rejected, not Lordship disposed of, but
Where,
they decided to proceed with the trial of the case.
where is that sentence?
Phase 40.
Hmm.
And last point, para 23, operative person is start from 23 para of page 40.
Yes. Then generally the
23. May I read, Lordship?
yes, please.
Generally, the issue on bar of limitation is pure question of law. Now, on the basis of Lordship, that preliminary issue framed by the learned court below, they made this observation. The issue on bar of limitation is pure question of law, but in our case in hand, this issue has become a mixed question of law and fact. How this is possible, Lordship? When I raised the objection regarding non-maintainability of the appeal on being barred by limitation, now they are saying that this becomes the mixed question of fact. And it is only through additional evidence, it can be determined whether the affiliates number 1, 2, 4, 5, 8, 9, 11 took part in the Kawang deliberations and the Kawang decision of 15/10/2013 and so to whether the application for the copy of the Kawang decision was actually applied for on 22/10/2014. 24. Depending on the conclusion arrived in both the issues, though the final argument or the judgment, the correctness of Kawang decision can be gone into after hearing the argument advanced by both the counsel. The additional evidence is ordered by this court in accordance with Order 41 Rule 27 1B of the CPC. Both parties are strictly directed not to adduce evidence on any other aspect, but to limited issues mentioned herein above by submitting list of witness along with
What is that limited issue?
limitation that I fail to understand also. Whether they are saying about the limitation, part by limitation or not, that I still confused also. Because reading of this order, I cannot come to any conclusion.
Okay. Ask Mr. Kelo, Learned Counsel for the petitioner. By filing this application under Article 227 of the Constitution of India, read with Section 115 of the Code of Civil Procedure 1908. The petitioner has assailed the order dated 2/6/2025 passed by the Learned Civil Judge Senior Division in Civil Appeal Kebab, within bracket Kebab, number 34, 2023, corresponding to Civil Appeal within bracket Kebab, number 3/14, bracket close. Whereby the Learned Civil Judge Senior Division Pasigat, ordered for additional evidence in accordance with Order 41, Rule 27 within bracket 1 within bracket small b bracket close of CPC. In the application, instead of passing order in the civil appeal Keba. No, this was for your application was specifically on barred by limitation.
Yes, sir.
Okay, instead of dismissing the civil appeal within bracket Keba being barred by limitation, stop para. It is submitted that when the Keba was decided, the Keba was decided on. When the Keba was decided?
Keba was decided on 15/10/2013.
They decided on 15/10/2013. 2013. In favor of in 2015 in favor of the present petitioner staff. The respondent appellant file the respondent the agreed respondent file appeal on when
21/11/2014.
file appeal on 21/11/2014, challenging the Keba decision dated 15/10/2013. After how many days you said?
After the delay of 370.
After the delay of 371
days.
1 days. Stop. However, the said appeal the said appeal was not accompanied by any petition for condonation of delay. Stop. However, the said appeal was lying pending before the court of the before the appellate court, that is the deputy commissioner, where? Which deputy commissioner?
Pasigar,
Pasigar. And on,
1, 2, and on,
when it was transferred,
it was transferred on Lordship.
the said case was subsequently transferred to the court of the
1, 2, 2023 only.
judicial court of the civil judge, senior division, 2023.
23. Yes.
Stop now. The petitioner filed an application raising the question of limitation, the question of limitation. Stop. The learned court has framed a preliminary issue as to whether the Keba appeal is barred by limitation. Stop. However, instead of deciding on the limitation, the learned trial court by an order dated by an impugn order dated 2/6/2025 has directed the appellant was directed. The appellants are directed not to disturb the possession of the respondent who is allowed. Okay, it is,
Appellants, this is,
please protect you.
yes, but this only, para is protecting me, Lordship. This only para, 27 is protecting me.
Yes. Okay, but then again,
Yes.
directing you not to erect any permanent structure.
Yes. Because, but they have decided to,
Where is the order for the? Just a minute. The civil judge by an order that is order for adducing additional evidence
yes,
in accordance with order 41, rule 27, within bracket 1, within bracket, a bracket close, within bracket, small b bracket close of the CPC starting. Para. Call for the record is necessary.
yes, necessary.
Call for the relevant record. Issue notice. The petitioner shall take steps upon the respondent by a registered post with AD within a week from today. Stop. List this matter after 4 weeks. Pass. In the meantime, it is provided that the operation of the, where is your interim prayer?
Interim Lordship. Page 31, 3-1.
Okay, so in the meantime, the order dated 2/6/2025 passed by the Nana Civil Judge Senior Division Pasigar East Young District shall remain stayed. And remain stayed. No, stop. What is this? This your another prayer?
This is another prayer, Lordship. In impugn order, para 27 is though protecting me, but when this honorable court is staying that order, then again the respondents, they will take advantage of that stay order, first on illegally, first on 6/5/20. Therefore, Lordship, then yes, in the meantime, the parties are may be directed to maintain status quo of the disputed
No,
land. In terms of
the operation of the said order itself is stayed. They are not required. Operation of the said order itself is stayed.
yes, but
Now-
Lordship, stay order was passed separately. So I have challenged under the
Okay,
CRP.
and in the meantime,
Yes.
and the party shall maintain status quo over the disputed land
In terms of government decision.
in terms of the Kabak decision dated 15/10/2023. Till further orders. Okay.
Lords.
This
Quickly
is matter after 4 weeks. Okay.
Quickly organize.
Yes,
May I please, Your Lord?
yes.
This is subsequent bail applications. The earlier bail application was withdrawn with the liberty to file a press matter.
File before this
Yes.
court.
Yes, madam.
Okay.
And madam, this matter, since this is a regular bail matter,
Hmm.
maybe call for madam.
Okay.
Scan copy of the TCR lordship.
Hmm?
Scan copy of TCR
Okay.
lordship.
Mr. M. Kapoor, land counsel for the petitioner. Sorry. This is an application filed under section 483 of the BNSS 2023 for granting bail to the accused, Elise accused. Sri Dorik Doji, who has been arrested by Alo police in connection with the Alo PS case number 14/2025 under section 21A, 27A,
Sorry.
and 27A of the NDPS Act 1985. Stop. Mr. Doi, Nara PP appeared and accepted notice. Staff called for the scanned copy of the case with charge sheet file not yet.
Yes,
Yeah.
ma'am. Filed.
Okay,
Subsequently, that has been filed.
the scanned copy of the case record. Which court?
District and session, special court, madam.
Hmm?
Special court allow. we sent.
Allow. Okay. You have, where have you mentioned the case number?
Case number, madam, it is in the cost title itself, madam.
Hmm?
Cost title itself, madam.
First, is PS case number is mentioned.
Yes, madam. I'll allocate.
Where is the case number? Because the record is to, if the record is to be called for from the court,
Madam,
it
in
has to mention the
connection
case number.
corresponding to this, my lord.
Hmm?
The case diary of corresponding to allow PS case number, madam.
No, you said a charge sheet filed already.
Madam,
Charge sheet filed or not?
exactly, madam. File, it is filed, madam.
Then
The
it is
case
pending before the court.
no,
only,
no, no, madam. Number is not given, madam. So therefore, madam, may I present, madam, the
Then it is a case diary.
case diary, madam.
It is still with the police or the case record is with the court?
My lord, with the court, madam.
With the court. Then
madam.
it must have been numbered.
So therefore, my lord,
Then because now it is no longer with the police.
yes, madam.
Cannot ask.
Therefore, my lord, my lord, my friend, my lord, case diary in connections to PS case number. my lord,
No, let me counsel.
my lord,
Mr. Kato, the-
yes, madam. Then
they
in
must
that
have
case,
registered.
my lord, I'll
Immediately after
furnish,
receipt, they used to enter.
I'll furnish the case record, madam.
Hmm?
I'll furnish the my lord case number, madam.
Right, that, okay, then,
Order may be passed, my lord. In the meantime, I'll furnish the
okay,
the
just
copy
a
of the.
minute, then after this, the land counsel for the petition submitted, the case has, after completion of the investigation, the case has already been charged sheeted before
Madam.
the special court, NDPS allow.
Madam.
Okay, stop, Okay, then after that, then call for the scanned copy of the
Yes, ma'am.
record of the number you give, Okay.
Yes, ma'am. Number I'll give, ma'am.
Record of allow
Session case
NDPS case number so and so, okay?
Madam.
Hmm,
Within hour, I'll.
hmm. Okay, list is matter after,
On 18 lordship.
on 18,
Yes, lordship.
list is matter again on 18, 18 is a,
Then is Wednesday
okay,
lordship.
18, okay.
Madam.
Yes,
Develop.
yes, yes.
In item number 4, Melon,
Hmm.
they accused applicant before your lordship is was the salesman of the employment complaint consumer goods and he was serving in the said company for almost 1 year as salesman knows the role of the salesman is very limited but complaint is against basically the manager of the company
Is it AB or BA?
wrongly
It should be
recorded.
AB, Lordship.
Hmm?
It should be AB, Lordship.
It is
Wrongly,
wrongly mentioned, It is 430, 482 application,
Yes, let us see the
yes,
allegation.
Yes, ma'am. Lordship will find the FIR. This FIR is basically against the manager, I have nothing to do with I have no any role, But I have been served the copy of the summon. Now, the petitioner is seriously apprehending arrest, So, Lordship has already granted bail to this main accused persons who has been named in the FIR, along with the other two other the person that has already been allowed.
In BA or AB?
It is AB, anticipatory bail. Lordship, we have annexed the copy of the order passed by your Lordship in the next
In the same FIR.
same FIR, I was the salesman, I have nothing to do with, Even in the FIR, the particularly, the manager has been named. I have nothing to do with, I have no role, I was just salesman of this said company, And salesman, the salesman role is very limited. His duty is to sell the items, goods and goods to the customer. Annexure, 1, page number 15 is the written FIR,
Election.
Annex, page number 15, Particularly, name of the manager has been given, to the officer in charge, page number 15, I'm reading, FIR against Sri Padma Bora, address so and so, so and so.
And you are?
I was the salesman of the said company,
Not Padma.
Lordship,
Not-
the elder brother of this Elise
But no,
accused,
yes.
Lordship. In bail application number 71, Lordship.
Elder brother of the
Elise accused.
the
In the name the
accu-
FIR.
named accused.
Yes, name accused, Lordship.
Okay.
In his account, money was transferred, Lordship.
Whose account? The
The
present accused.
present applicant,
Is
Lordship.
Padma Bora transferred in the account of this Jayanta Bora?
Jayanta Bora and his wife, Lordship, Srimati Jansnak Watch, something, Lordship. Page number 16, Lordship.
Named the manager, Ellis manager, Lordship will find it, annexure, may I take your Lordship to the, and again, annexure, second annexure,
Just a minute, just a minute. Let us see the allegation against.
Yes, madam.
If there is any against him.
with married,
And the owner of this GG consumer. So the owner of the GG consumer has filed this.
FIR,
Would like to make the complaint. Padma Bora incident so. He was a manager. He was working, okay, so here also he says that he was working as a manager. And Okay, what about the wife was also? Wife is also made as a accused.
Right.
Yes.
Well, my submission is be that as may be.
Yes, but then clearly stated in the FIR also.
Yes, my lord. Yes, my lord.
And Lord,
You are also named FIR.
No, my lord. I'm not named, my lord.
No, brother says.
His name was
clearly,
mentioned
Mr.
in the
Devendra
FIR.
Bora. You see, page 16.
Page 16,
Hmm.
my lord, it is in respect of, my lord, the main accused, Mr.
It is,
My lord.
yes.
It
Your
is
name
also,
appear in the
it is
FIR.
also learned that the embezzlement amount has already, has been transferred to the accounts of his, my lord, that is the, my lord, the allegation, my lord, the
Yes.
subject matter of investigation, my lord.
Yes, but he is
So
a name
therefore, my
accused.
lord, the whole, all things, everything has been done by my own brother, my lord. That categorical statement I have also made, my lord. So therefore, my lord, and your lordship has already granted bail to the other accused person. If lordship perused, my lord, page number 18, the order passed by your lordship. My lord, we are ready to cooperate, my lord. This is, my lord, allegation against me, my lord. I, by virtue of my lord salesman, has nothing to do with my lord.
Lordship, here the alleged accused, the name the FIR Lordship, Padma Bora, despite getting interim protection from this honorable court, they didn't appear before the IR Lordship. Is it page number 21? May I take to the page number 21?
That case doesn't you file for the cancellation.
Yes, my lord, that,
Yes.
that is another, my lord, aspect, my lord. That is another procedure. There is another procedure, my lord, for cancellation. But my lord, at this stage, I am not, my lord,
Okay. Understood.
Lordship, this
I'm
matter
ready
may be
to-
taken together on 16 since CD was called for Lordship.
Where? CD call for?
On 16 Lordship,
In which case?
the Padma Bora Lordship.
in
Padma-
other
Padma
case,
Bora, in other
in
case,
other
Lordship.
case, bail application, my lord, is
In other case.
bail, my lord, AB
application
number
of-
71, my lord.
Okay, this 71.
Yes, Lordship.
Well, that cannot be, my lord. Some other appropriate that may be fixed, my lord, since though it is connected to same PS case number, my lord, however, my lord,
Whereas of the same FIR Lordship.
my lord, only I'm praying your lordship is, my lord, on ferity, my lord, at least I may be given opportunity to, my lord, give my statement before the eye of the case.
Since, in other case, yes, what is this another? In the case of this Padma Bora,
Page number 21, my lord.
Lordship, on 21/5/2025, interim bail was granted to this Padma
okay, so it
Bora.
was continued.
Yes, ma'am.
Yes, continue.
However, directed to, my lord, the appear before the eye of the case, my lord. That I am ready to cooperate with, my lord. This is, my lord, regarding money transaction, my lord.
Heard Mr. M. Kato, Land Council for the petitioner. Stop. By filing this application under section 482 of the BNSS 2023, the petitioner is seeking pre-arrest bail, apprehending his arrest in connection with Itanagar PS case number 76,
Madam,
2025, under section 408 stroke 120B of IPC. Stop. Stop. The Land Council for the accused applicant submits that he is innocent and has nothing to do with the transaction between, nothing to do with the alleged transaction or embezzlement of the amount by his younger brother Padma. What is his name?
my lord, I am Jayanta Kumar Bora.
Padma Bora. Padma
And-
Bora.
Manager is the, yes, my lord, Padma Bora.
However, based on the above FIR, the police has registered the above Itanagar PS case number 76/2025 under section 408/120B of the IPC. And you have been issued notice.
my lord.
Have you received notice? It seems you have received notice from the police.
Yes,
Okay.
page 17, my lord.
Yes. Durham Police section so and so, and issued notice directing him to appear before the eye of the case. When you are directed to appear?
On 17, my lord.
On 17?
Yes.
17/5.
Yes.
17/5 is gone.
My lord, this is the first notice which I have received, my lord. Thereafter, I have not, my lord.
You did
Therefore,
not
I am
appear. You
yes.
did not appear.
Yes, my lord. Therefore, I am apprehending, my lord.
It's today is
17 May, my lord.
You did not appear. Why you did not appear?
No, my lord, on that time, my lord, I have not received the copy, my lord. Of late, I came, my lord, I am residing in Assam, my lord.
Okay.
Because I already stated
17/5,
that
2025.
they are not cooperating.
When did you receive?
My lord, it is also not, my lord, particularly mentioned.
Which he has received after the 17/5/2025 stuff. Therefore, he has a reason to believe that he may be arrested in connection with the above PS case and cause unnecessary harassment. Hence, this application for grant of pre-arrest bail, staff para issue notice. Since Mr. D. Lloyd, Lana PP appeared and accepted notice on behalf of the state respondent, no formal notice need be issued. Staff. Call for the scanned copy of the case diary of the PS case number 76/2025. The learned counsel for the petitioner at this stage submits that the main accused, Sri Padma Bora, has been granted interim protection by this court on 21/5/2025 and prays for similar on staff para. Is prayed for by the learned counsel for the party. List is okay. The further the learned counsel for the learned PP submits that the matter, the bail matter, the bail application number 71/2025 is fixed on
16.
16/6/2025. Start. List this matter again on 16/6/2025. Stop. Para. In the meantime, comma, in the event of the accused applicant, what is his name?
Jayanta Kumar
Jayanta
Bora.
Kumar Bora is being arrested in connection with the above PS case number 76/2025, comma. He shall be released on interim anticipatory bail on execution of a
Right.
bail bond of rupees 50,000 with one surety of like amount, comma, one of which shall be the resident of state of Arunachal Pradesh,
Right.
with a further condition that the accused applicant shall appear before the eye of, cooperate and appear before the eye of the case as and when called for.
Well,
Two, that the accused applicant shall not hamper or tamper with the evidences of the case in any manner. Stop. Next, that the accused applicant shall not directly or indirectly make any inducement, comma, threat or promise to any person acquainted with the fact of the case so as to dissuade him from disclosing such fact to the court or to any other officer, staff, listed on 16/6.
man,
Okay.
well, additional correction, man. Registry may be directed to number that, man. This is AB, man. registry may be given
The
directly
cause
to,
list, Lordship.
to correct the or re-register the name bail AB from BA to AB .
Okay. It is seen that the application was this application has been just a minute.
Renumber.
This application has been filed as anticipatory bail. However, the inside it is anticipatory bail only.
Yes, madam. But in the normal bail, it has been regular bail, bail application only. A BA as per register. But it should be
No. So in the course title, anticipatory bail number 70. It's 70 only.
but in the court list, and other thing, other
Okay.
record.
However, just a minute. It is seen that this anticipatory bail has been numbered as
Bail application.
anticipatory bail number 70 of 2025 in the course title. However, it has been listed as, in the course list, it has been listed as
Bail application.
BA 70 2025 stuff. The registry shall correct the same. The registry shall do the needful and correct the same.
Well, different.
May I please, my lord.
Yes.
My lord, this bail application arising out of the NDPS case number 86 of 2024. And this is the subsequent bail application, my lord. The FIR is at page number 14. It is very visible at typed copy at page number 16. Kindly come to page number 16, my lord.
Yeah.
This is the FIR typed copy FIR. Here in the FIR, there are 4 persons has been named. And I am
Complain
number 1.
against so and so.
Yes,
You are,
I am Taril Kumar. 1.
you are, okay, Terry.
Yeah.
Okay.
And 3 more are there. Here. And my lord, after basing on this FIR, the accused person was arrested on 19/8/2024.
Just a minute. What is the allegation against you?
Allegation is that
Please.
on 18/8/2024 at around 11 p.m., one Srimati Tolum Yaro and his son Sri Tolum Mona came to my residence and informed me that the above mentioned person had brought my son late Pate Tako in a mysterious condition at her neighboring house of one Sri Muhammad Asmat Ali. After hearing such, I, along with my family member, went to the spot near railway track, Tikdo village, and we saw that my son was laying dead at the said spot. After inquiring Muhammad Asmat Ali and 2 informants, they have disclosed that the above mentioned accused person has dropped my son at his house, that is Asmat Ali, and flee away. As such, there is an apprehension that the above mentioned 4th person had murdered my son and left away the spot. Here is the allegation that allegation of murder of one person, one named Pate Tako. So on the basis of this FIR, the present accused person has been arrested along with these 4 persons. And thereafter, during the course of investigation, 2 more persons were also arrested, my lord. And after that, after getting arrested, those persons, my lord, 2 of them, total out of total accused, 2 persons have been declared juvenile and get bail from the Juvenile Justice Board. And 3 persons has also got bail, that is Tok Lel, released from JMFC Ethiopia on 27/8/2024. Another one, Tok Mona, also released from the JMFC Ethiopia on 28/11/2024. And another accused person, Tana Karung, released by this honorable court on 29/1/2025, page number 26. Here, I have filed.
Two were juvenile, found
No,
juvenile.
no, I am not juvenile.
No, two.
Two were juvenile out of 6 accused. Age per the FIR, 4 persons is there, including me. And during the course of investigation, 2 more persons was arrested.
Hmm.
2 more persons was now total 6 persons, 6 accused
Arrested.
arrested. Then out of these 6, 2 was declared as juvenile, who got released on bail from the Juvenile Justice Board on being their juvenile. And 2 persons was also released from the JMFC Ethiopia on the ground of HIV positive. HIV positive. Now, another one, Tana Karung, who is also in the FIR, was also released from this Honorable High Court on 29/1/2025, my lord. And my lord, I have filed bail application before the Session Court Ethiopia, but my application has been rejected. Rejected by the Session Court, my lord. And thereafter, my lord, I have filed,
Teri Akkar.
my lord.
No, no, ye Teri Kumar.
Yeah, Terry Kumar, my lord. At NHR to page number 19, it a rejection
Oh,
order.
yes.
And thereafter, my lord, I have filed bail application before this honorable court.
Yes, it was rejected.
This was also rejected on the ground that the bail application will be considered after the examination of all the witnesses, my lord.
After all the,
These witnesses.
okay, now.
So here,
now
Your
whether
Honor,
the witnesses has already been examined.
my lord, yes, already charge sheet has been filed. On 3/10/2024, charge sheet has been filed, my lord.
No, it says the examination of the witnesses by the trial court, it says, not
Trial-
by the police.
Trial court, my lord.
Yes, see,
And then,
examination of the witnesses by the trial court.
yes, my lord,
That means in the trial.
it is not yet commenced, my lord. So only it is,
Then you have to wait for some more time.
my lord, it is the only stage of afference. Because I am still behind the bar.
Now, unless you challenge this order, then it's difficult.
My lord, I
You have
am
to
still
abide
behind
by
the
this
bar.
order.
I am regularly appearing before the trial court.
No,
But
you are in the jail only now,
I am in the jail, my lord.
so you are bound to,
So, and
you are
apart,
being produced.
apart from me, my lord, 3 more persons who are released on bail, they are not turned up. For them, I am suffering. They are not turned up. So I am regularly
no,
appearing before the
No,
trial court.
The accused is not appearing.
Other accused, those who are on
Accused.
bail.
No, but then we are not concerned with the accused, but the examination of the witnesses as per this order.
As per the High Court order.
See page 22. Is witness by examination of the witness by the trial court.
Yes,
Unless we challenge this, unless this changes, it will be difficult.
As per the High Court observation, my lord. So
Yes.
there are 18 witnesses.
How many of them have been now examined by?
No, none of them.
Oh,
None of them have examined, my lord. So it will take long time.
you were advised to come back after, before this court.
So it will take long
Again,
time, my
after
lord.
the examination of the witnesses by the trial court. So then unless we challenge this, unless this order goes, it will be difficult.
My lord, it is 18 witnesses are there
Yes,
in the case.
maybe.
So it will take more than years together, my lord. So why I should suffer? Since the similar situated person, those who are in the FIR, whose names are also in the
Not even a
FIR,
single witness examined.
my lord.
Now it's premature then.
My lord, similar situated person whose name are also in the
Maybe,
FIR.
but in your bail application, while disposing of this condition is there.
My lord,
Unless
here
you challenge this and unless this order changes.
that is there, my lord. But here I am filing my subsequent bail application on the ground that, my lord, my father has got brain stroke.
Maybe.
So,
In that case, you have to file for the temporary bail,
my lord,
not the regular bail, because in the regular bail, the condition is there. You have to, you are asked to come back after, again, after the examination of examination of all the witnesses by the trial court. So unless this order goes, It's very difficult.
Yes, age for disorder, I
We are
have to wait.
provided by this.
Age for disorder, I have to wait till the completion of 18
Yes.
witnesses.
So
But-
if it is a temporary bail,
Yeah,
because this condition, unless you challenge this, no order can be passed.
yeah, my lord.
And then if you are praying for the temporary bail by showing cause that with all those documents, then
Yes.
you can pray for the temporary bail and we can grant temporary bail for say 10 days, 15 days.
Yes, yes.
But then during the existence of this order, it will be difficult. So what to do?
So age for disorder, I am
Yes.
bound to
Yes.
linguistic behind the
You
bar.
withdraw and file separate. Either you challenge this or temporary order.
Yes,
Temporary.
no, I will file temporary bail application.
Okay.
I am liberty maybe.
Okay.
Granted, my lord.
Mr. Yantaji, Land Counsel for the petitioner wants to withdraw this bail application with liberty to file afresh. This bail application is dismissed on being withdrawal with liberty to file afresh if so advised. Okay.
Yes, my lord. Obliged, my lord.
None appears on behalf of the petitioner on call. So please this matter after. Okay, just a minute. None appears. Okay, please this matter after 2 weeks. Yes.
Yes. Yeah, you know.
Yes.
Lordship. Lordship, this is a joint petition under section 528 of BNSS for quashing of criminal proceedings arising out of Basar PS case number 8/2015. Booked under section 332, 353, and 34 of IPC. Where petition number 1 is the informant, 2 is the victim, 3, 4, 5 are the alleged accused. Your Honor,
One is
one is the informant, your Lordship.
informant.
Yes, 2 is the victim. And petition number 3, 4, 5 are the alleged accused. Your Honor. You know, the gist of the case is that
Just a minute. Where is the allegation against the accused?
allegation
What is the section involved?
sections are it's in para 2, Your Lordship.
Let us see the FIR.
Fire is in annexure 1, page 21. Yes, Your Honor. And type copy is in page
What
24.
is 353?
Your Lordship.
IPC 353. What is the punishment?
353 is Your Honor, punishment is up to 2 years or fine.
What is this?
This is Your Honor, assault or criminal force
Okay.
to
and
deter public servant from
332 punishment.
332 is voluntary causing hurt to deter public
Punishment?
servant. Punishment is for 3 years or fine. Both are non-comparable, Your Lordship.
2015 case.
Yes, Your Lordship, but the section 353, it's against the public servant, my lord. And so far as the record is concerned, Your Lordship, the perhaps the trial already commenced, Your Lordship, and it's in 313 stage. The case, the
Three-
present,
three states.
yes, your lordship.
Yes.
Okay.
Lordship.
So, your lordship, the TCR is not the updated one, your lordship. The call for the updated because there is no any interim as such.
2024. Last order it appears.
It's there in the your lordship official record, your lordship. The matter was fixed for 313, your lordship, which is bars of completion, your lordship. We don't know whether the trial has been completed or not, your lordship.
Today the case is.
Next is given
We
to
have
the
no
month
idea.
of
And
August.
this is way back in the year 2024, 313. Present. Now you have to see on, because after that, after recording of 313, after examination under section 313, probably the judgment also maybe
Yes,
might have
yes.
delivered. You
Yes,
have to
yes.
update.
Yes,
We
you
have no
also,
idea.
the stage for 313 is
Which-
fixed
which
for the
court?
month of August, this coming August.
Hmm?
Lordship. This stage for 313 in the CGM court, alone, is
Hmm.
fixed for the month of August.
For 313,
Yes, this coming month. Coming August 2025 is fixed on August 2025, Your Lordship. But I'm not aware of the exact date.
you have seen the,
During the
Evidence.
filing of this,
Yes, your lordship. 313, your lordship. I have seen the record. It's for 313, and your lordship. My only objection on the 353, your lordship. It's not about the offense, but
So-
the imprisonment, but it's against the public servant, your lordship.
so, from the deposition, from the evidence, could you find that he was on duty? On the
Yes, your lordship.
Lordship,
They were on duty, your lordship.
Huh.
They were on duty. So
Then-
they have assaulted the.
Then it is beyond the individual.
Yes, your lordship. If your lordship, in this kind of cases, if
It will be
quashing is
difficult. It will
allowed,
be difficult.
then your lordship, it will be very easy for the civilian to assault the public servant at any
No.
time. And later on, they will convince and come before this court to invoking inherent power and quash the matter.
Your Honor, in this instant petition, Your Honor, in this instant case, the parties have already mutually and amicably,
No, he was
Resolve
a
the
public
matter, Your
servant,
Honor.
public servant. What is?
and Your Honor, during that
And
time,
then-
there's a slight misunderstanding between them, and there is only confrontation between this
Why you had
petitioners.
to- Why you had to
Lordship.
confront with, that is also the police personnel.
Yes, Your Honor.
And then if the civilian start assaulting police person and then thereafter compromise,
Your Lordship, if
then it becomes very difficult, it will become very difficult.
Your Lordship may go through if my this petition in para 6, Your Lordship. Here I stated that petitioner, particularly the alleged accused, stated that. May I read out, Your Lordship?
What? Your statement?
Yes, para 6,
No.
Your Lordship.
No, your statement, because when there is evidence all around, so your statement, you will say so many things, but then you
Your
see
Lordship,
evidence of that.
If I may allow Your Lordship, if Lordship may go through the trial court record, the deposition of the victim itself, he stated that he is not recognized the person who assaulted him.
So that is why you will be
It's-
acquitted, then why to
Yes.
worry now? But why this 313 is also taking so much of time since 2014?
Because
Yes,
your
24.
Lordship, the petitioner are
Yes.
of a very young age now. They have recently started their family, so, and Your Lordship have all the inherent power.
They must be settled now. It's the case of 2015. Now, Mr. Te, what is your submission? What to do? So it's not updated, of course, but
Yes,
then
it's not updated, and your lordship,
Yeah,
there
have
is no any interim as such. No interim also.
no interim.
Yes,
also.
your lordship.
Then in that case, that will proceed. 313.
Because your lordship, so far as your lordship punishment is concerned, your lordship, Lakshmi Narayan case is very clear. It doesn't speak about the punishment. It's about the against the society,
Yes.
or if it's fall under the serious offense or heinous offense like rape, dakaiti. But now, if public servant is involved, and if they fail to establish or satisfy this court that 353 is not attracted, then this court should refrain from exercising inherent power, Your Lordship. Otherwise, Your Lordship, if the public servant in this kind of offences, Your Lordship, if the court exercises inherent power without giving any reason to a satisfaction that this section has been inserted only for the namesake, then, Your Lordship, it will have a wrong signal to the society, Your Lordship.
Now, in order to dispose then whether there is any, all this deposition, the evidence of the projection witnesses are to be seen again.
They may have a good case for acquittal, my lord. They may
That's
have
why
a
I'm
good
saying-
case
that
for
is why I'm
acquittal.
saying 313 stage. Why it has been fixed on August? This is June only, July, August.
It can be
Yes,
expedient, Your Lordship. Your Lordship may direct to expedite the trial, since because there is no any interim or protection, Your Lordship, because this case was, Your Lordship, moved on 6/11/2024.
Do you have the order, last order of the trial court?
No, Your Lordship. I haven't-
Mr.
T. Pumbo.
Non-counsel for the petitioners. Mr. P. Leonard additional PP. Some is that the trial court record as called for is not updated. One. Moreover, it is at this, moreover, the trial of the case is at the stage of examination of the accused under section 313 of CRPC. The learned counsel for the petitioner at this stage submits that the next date of the case is fixed on August.
Yes. Month of
You-
August, Your Lordship.
Hmm?
Yes, August.
Date you have.
Date exactly, I don't know.
Okay,
Your
in the month of August 2025. So, para. Mr. Edwards submits that since the case involved with the assault of the public servant at this stage, unless the updated record is seen, no other may be passed. So, in view of the above comment, and he further submits that the next date fixed on August by the trial court can be preponed for to expedite the further trial. So, in view of the above, call for the updated scanned copy of the case record. So, the judicial magistrate, sorry, the chief judicial magistrate. Hello. Shall expedite. In the meantime, the chief judicial magistrate. Hello, shall expedite the further trial of the GR case number 307/2015, arising out of Basar PS case number 08/2015, and prepone the examination of the accused persons under 313, under section 313 of CRPC within 30 days from the date of receipt of this order. Stop. Okay,
Yes, your lordship.
list this matter again after.
Your lordship, maybe after 2 weeks, your lordship.
After
3 weeks, your lordship.
After 3 weeks, okay. On which date the additional PP shall produce the updated,
Your lordship, registry, your lordship.
the registry shall. Okay, registry shall produce the updated
This
case
year.
record. Okay.
Yes, sir. Oblige.
Yes.
Yes, Your Lordship, so far the accused person is in illegal detention for more than 1 year and 2 months. Your Lordship, he was
What is the allegation?
allegation, Your Lordship, he was arrested under section 21B of NDPS Act. Your Lordship, he was arrested merely on the statement made by the other co-accused. Your Lordship, come to the statement of the disclosure statement of the co-accused.
TCR not received, your lordship.
Hmm?
TCR not received. TCR was called for.
PCR was called for, not yet received. Record would be necessary.
Yes, your lordship.
What is the status of the trial, by the way? Trial
CC has
begun.
completed.
Charge sheet filed, my lord.
Charge sheet has been filed. I have enclosed the charge sheet, Your Lordship.
Okay, charge sheet file. Whether the trial begun?
Yes, Your Lordship.
Okay.
The next
Charge frame
speaks
against
for-
accused?
Yes.
Then trial commence.
Okay, whether any witnesses examined?
Witnesses, no, Your Lordship. On last day, PW was fixed, but it was postponed because the learned special judge wasn't
Okay, with the case of which year?
2024.
24 only.
Yes, Your Lordship.
Okay. Which court?
Special judge,
Special Judge UPR?
UPI, Your Lordship.
Okay.
Your Lordship, just come to the
No.
Caesar memo, Your Lordship.
Maybe, but then let us wait for the.
TCR as well as your lordship CD will be required because here also my learned brother has taken a plea of ground of arrest not been communicated.
Oh, is it?
Yes, your lordship.
In the case, Your Lordship, neither the ground has been communicated nor, Your Lordship, the reason for arrest has been given in the arrest memo.
No, not in the format. Format also not fit up.
No, Your Lordship.
For that CD has to be looked into, your lordship.
Then probably,
Because your lordship orally also it can be communicated. Now whether it is there or not, it has to look into from the case diary, your lordship.
Hmm.
And so far as your lordship, it's a success. In many occasions, bail has been rejected. But yesterday, my learned brother has submitted one judgment of our own bench, where your lordship, it has been settled that even in successive bail, that issue can be raised. It was if it was not raised for the first time.
okay.
But in that case, only sections under which the case has been registered has been furnished to the accused, but no reason or no ground of arrest was communicated in that case, your lordship. So here, your lordship, although there are rejection of bail applications are there, order are there, but if this plea was not taken before the trial court or even before this honorable court, then that can be considered. So to ascertain that, your lordship, case CD would be required.
Okay. Mr. You are Mr.
M. Kamcham.
M. Kamsam, non-counsel for the petitioner. Also heard Mr. Theatre, learned additional PP. So it is submitted that the ground seeking for bail, the petitioner sorry, it is submitted that the petitioner is also seeking bail on the ground that the no reason or ground for the arrest of the accused has been furnished. Therefore, the case diary of the what PS, which PS?
It's Bandardua PS case number
Bandardua
32 of
PS
24.
case number
32 of 24.
32. Where have you mentioned?
Your lordship, in
PS
court's
case?
title they have given, and even
Court's
in
title
and even
PS
in-
case is given. Okay, Bandardua PS case number 32 stroke 2024 would be necessary. So in view of the above, call for the scanned copy of the case diary
as well as TCR, my lord.
As case diary of Bandadwa PS case number 32, 2024, as well as the trial court record of GR. Where is the GR case number? What is the GR case number? Or GR or the NDPS case?
GR case, your lordship.
Trial court record of the not, I think not numbered, not given.
I think it's reflected in the bail order.
Mention the number, it will be
Yes,
difficult.
GR case will be required, your lordship. GR for the TCR, GR would be required.
So you have nowhere mentioned GR. That is why probably
Yes.
while calling the record also, it was mentioned.
It is
of the
difficult
PS
to
case.
find out, your lordship. It's difficult to find out the cases.
It's difficult. As well as the trial court record from the special judge NDPS UPR. Arising out of Bandadwa PS case number 32, 2024. Within bracket, state versus, what is the name of the accused?
Arif Islam.
Huh?
Arif Islam.
Arif.
Yes.
Arif Islam, bracket close. Start. List is matter.
That is written Navam. Navam.
There are total 4 accused, your lords, 6 accused.
In single bail application.
In what?
No. In the case, your lordship, there are total 6 accused.
Okay.
I'm filing for only 1 accused.
Navam Timothy is the
Main accused, your lordship.
accused here.
Yes.
An applicant is the Solu Islam.
Solo
So
Islam.
Navam Timothy, your lordship. He's
Yes, the post title is Navam Trimurti and others, your lordship. And the Arif Islam is one of the accused.
okay.
Okay, then postal Nabam.
Your lordship, his
State
name
versus
State versus Navam Trimurti and others.
Nabam
Trimurti.
spelling.
NABAM. Navam.
Yes.
Timothy. TIMOTI.
MOTI.
TIMOTI.
Yes,
Oh,
sure.
Timothy.
Yes, Timothy.
I thought Timothy. Okay. List is matter after
2 weeks, your lordship.
2 weeks.
Your lordship, short date may be given because on last date 2 weeks was taken, your lordship. On 26th of last month.
After 10 days. Okay.
Oblige, your lord.
Oblige.
Yes.
Yes, Your Honor. Your Honor, this is a case regarding the custody of a minor's child.
Regarding?
The custody of a minor child. Here, Your Honor, Your Lordship, here, in the year of 2022,
Who is for the respondent?
I'm for the applicant here.
You are for the
I'm
applicant.
for the appellant.
You are appellant.
Yes, Your Lord.
Who is for the respondent?
Your Lordship, as per record, Your Lordship, the service report is yet to be completed.
Okay. Not yet received. Have you taken steps? When?
Yes,
did you take
yes,
steps?
Your Lordship. We have taken, Your Lordship.
When did you take steps? Service report not yet received. When did you take steps?
Your Lordship,
Probably
it is.
long back, I think.
Yes, Your Lordship.
So then I think because it was the office note reflected service report awaited since February. Probably, and then you have taken a step in the November 24 only. Probably you may have to take press steps.
Yes, Your Lordship.
It is better, no point waiting for. Okay. In view of the office note dated 9/6/2025, Mr.
N. Kakum.
A.
N. Kakum.
N. Kakam, Direct Counsel for the appellant. Praise for allowing him to take press steps upon the respondent. So the prayer is allowed. Step upon the respondent. How many respondents are there?
Only one respondent, sole respondent.
Steps upon the sole respondent by a registered post with AD as well as by an usual process within 7 days from today.
Yes,
So-
yes, Lordship.
Okay, list this matter after 3 weeks.
Yes, Lordship. Your Lordship, there is an entry, Your Honor.
There is interim.
Yes, Your Lordship.
The interim order passed earlier shall continue till the next date of listing.
Deeply obliged, Lordship.
Interim order was passed in IA.
In IA,
Okay.
in IA 64. In IA number 64 of 2024.
Okay.
Deeply obliged.
Mention as the interim order passed in IA 64. ISC 64 AP 2024 shall continue till the next date of listing.
My lord, there is some correction need in item number 12, my lord.
What is?
Your lordship, here in this case, the earlier bench of Justice Y. Longkumer has disposed of the matter.
Which one?
Your lordship, in the same FIR, in the same accused. On this case, the bail application, your lordship, the earlier one.
Bail application was disposed of.
Yes, your lordship. So it has to be placed before the Justice Y. Longkumer. So as per the notification
Then
27.
then in the allegation, list it before the appropriate.
Yes, your lord, because I have not seen this order, because this is the order passed by the
Okay.
Justice Y. Longkumer. Your lordship. Here it was disposed of, giving him the direction to learned court below to consider his bail application there. So far as notification is
In
concerned,
respect of other accused persons.
this accused, same accused only.
Same accused.
Yes, your lordship. And so far as your lordship,
This
if
is this was
subsequent, your lordship.
subsequent.
Subsequent.
Okay.
So we have to see the only FIR, your lordship. It's not even,
Oh.
it's not required to see the accused.
After that 3 weeks, huh? Release it before the appropriate.
Appropriate, yes, your lordship. Oblige, your lordship.
Appropriate bench. Huh?
Appropriate.
Okay. So this was item
12, 12, my lord.
Okay, that was 12. This is 13. Now,
Oblige, your lordship.
yes, next. Last, let us see.
Chief, I'm appearing on behalf of Titagum, legal counsel, appellant. Lordship, as per instruction, he has received the paperwork yesterday only.
Okay.
Therefore,
you are for
appellant Titagum.
appellant, and who is for the
PP.
okay PP? Who appear for the state? State has also received paperwork. Then can we list it for hearing next week? What is this matter about? The appeal is against?
I have no
idea. Okay, Mr. You are Mr.
Arkoyu.
Arkoyu. You are legal aid counsel.
No, I'm appearing on behalf of Titagum. Titagum is the legal aid counsel
Okay.
appointed.
Appearing on behalf of Mr. T. Tagum, learned legal aid counsel, some steps the some is that the learned legal aid counsel has received the paperwork. What is the mention about? Since the paperwork is received by the learned counsel for the parties, let this matter be listed for hearing next week. Okay.
May I pray for 3 weeks because
weeks.
the
Okay. List this matter for hearing after 3 weeks. Okay.
Oblige, your lord.
Then rest we can continue at 2.
Okay.
No, 23.
No,
22,
22.
no.
22. Not yet.
I'm informed, my lord, counsel for the Malay State, additional PP, Mr. T. Tato
Ah.
is not feeling well. So
Respondent. Yes, for private respondent. So you are for?
I'm for the petitioner, my lord.
You are for the appellant.
Appellant, yes, my lord. I'm for the appellant.
Okay, now in that case.
Item number 22, yes, my lord. So subject to the convenience on the part of the my lord, the board counsel for the other
After
party.
one
I am
week.
ready, my lord, otherwise.
When?
After 1 week only.
After 1 week.
My lord, may I please let us
Okay.
have the fixed date.
It
So
is
that-
submitted that the learned additional PP, Mr. G. Tado is not well today, therefore praise for adjournment. Stop. As requested, let this matter be said after a week.
After a week.
Okay.
My lord, if possible, fixed date may be given more so that we can.
After consulting each other, let us have a fixed date.
Yes,
We will make mention. No
Okay.
problem.
Okay.
that is fine. Wait.
Obliged.
Deeply obliged.
Yes. 16 is 4. Legal aid counsel is not appearing. So whether the party, what is this appeal against?
Appeal against
What
judgment and sentence dated 29/50/2024.
376, okay. So then there must be a private respondent also, the victim, whether the victim has been informed or
Yes,
the notice was served.
Yes, notice was served. For the victim,
Legal aid counsel,
legal aid counsel was appointed.
okay.
And she was appeared before this honorable court also.
Now, whether, okay, have you received the paper book?
Yes, I have received the paper.
Have you received the paper book? And legal aid counsel also, probably, then we'll fix it for hearing. Okay. Okay, the judgment was passed on
Judgment was passed on
24.
yes 29/05/24.
You will have hearing the entire matter itself, okay. Had Mr. K. Posi, learned counsel for the appellant. Also had Ms. L. Hage, learned edition of PP for the state. No one appears on behalf of the private respondent. Earlier appeared legal aid counsel.
Yes, she was appear. Today, one of his her associate informed me that she is not well.
Who is the legal aid counsel?
She Earing. Christina Earing.
Okay, then the parties have received the paper book. In view of the above, let this matter be listed for hearing after 3 weeks. After 2 weeks,
Because the convicted person is under custody for long days. Short
it
date.
was convicted in the year 2024 only.
Yes, it was almost 1 year in the custody.
1 year is nothing out of the year. He was convicted for 376. Actually, Your Lordship, in this case, only on the sole testimony of the prosecutrix, the accused
What more
person
you
was.
want in 376? What more you want? Who will see? Is there any, no possibility?
Do agree, Your
No,
Lordship.
then,
In that case, there is many catena of judgment of the Supreme Court and this our High Court also. That in the
okay, you, during hearing, you can just place it. Okay, so this is after 2 weeks?
yes.
Okay, after 2 weeks, okay. For hearing, huh? Yes.
Obliged.
Yes,
Wait, what is this?
yes.
Division petition. The other side is absent, I think.
Oh, this IA is for what?
IA is for condonation of delay, Maharaj.
Not yet condoned.
Not yet gone.
They-
They have to file the objection.
they
They have
filed
not
objection?
filed, not yet filed.
Earlier they appeared, otherwise.
Sometimes I think beginning.
Have you taken steps?
Yes, sir.
Not yet file objection. We wanted to file objection.
The last chance will be given.
Last chance.
Last chance.
How many days? Delay of how many days?
1 year. 1 year.
One?
365 days.
365 days. Okay, then one last chance can be given. Otherwise, you see, they have been given 1, 2. Already 3 chances given. Okay. But then, no, 2 chances. And then on the third day, you submitted that you have intention to settle the matter. There was some negotiation.
Some negotiation.
probably was
Yeah,
going
that
on.
is of course
That failed.
not yet done.
That failed.
Failed.
Okay. Direct counsel for Mr. Tishon, direct counsel for the petition. None appears on behalf of the respondent. It appears that the respondent was given an opportunity to file affidavit. However, the file objection. However, the respondent has not yet filed any objection to start. For the end of justice, the respondent is given one more chance, one more opportunity to file objection. Stop. List this matter after 2 weeks. After 2 weeks. Okay.
Oh, right.
Code this as a jail, criminal appeal jail, but it is wrongly reflected as jail appeal. It cannot be.
So
Why? Because, Your Lordship, the appeal
registered jail appeal only.
appeal has already been heard by this honorable court on conviction. Now here, Your Lordship, they are challenging that the complaint has not been entertained by the learned court below under 340 of the CRPC for perjury. So now the question here is, Your Lordship, the court, this honorable court, the coordinate bench, has upheld the conviction.
Okay.
And subsequently that the same was challenged before the Honorable Supreme Court.
Hmm.
They also not interfered, upheld the finding of this Honorable Court. And again, they filed a review petition, which is again dismissed by the Honorable Apex Court on the ground of delay as well as on merit. Now, they are come with a plea that some perjury has been happened and committed by the prosecution side or the victim side. Now, that aspect has not been considered or not been placed before the appellate court. Now they cannot take all this plea. It is otherwise it is afterthought. Because if suppose there is some material then they ought to bring it by way of exercising 391. If not in the High Court, before the Apex Court. That they have not done. Now the matter has reached its finality. If your even review is dismissed. Now only because your lordship did
The
their
review lies in the criminal.
your lordship review in the SLP, your lordship.
Okay.
Your lordship, I will just your lordship for your reference, your lordship, I will apprise this court the order, your lordship.
Okay, the conviction was by CJM.
You know, your special
Conviction-
court is a POXO matter. Lordship, that was the judgment from the our own coordinate bench.
Hmm.
It is reported also in criminal appeal 34 of 2022. Now, against this criminal appeal, they have prepared SLP. Your lordship, that is the SLP order. It clearly says, we are not inclined to interfere with the impugned judgment and order of the High Court. Accordingly, the special leave petition are dismissed, pending application, if any, shall stand disposed of. Now, here, your lordship, the review petition means the SLP.
Okay.
This one, your lordship. Here, your lordship, the Honorable Apex Court held that despite the fact that there is a delay of 506 days in filing the review petition for which no satisfactory explanation has been furnished, we have gone through the review petition. In our opinion, no case for review of order dated so and so is made out. The review petition are dismissed on the ground of delay as well as on merit. So therefore, meaning thereby, your lordship, the Honorable Apex Court has perused the record also, everything. Now, they come with an allegation of perjury, which has been dismissed by the Honorable
Now
Court.
at this stage, when the matter has reached finality, it will be a little difficult.
Yes, absolutely, your lordship, because the evidence which has been produced before this Honorable Court and which has been reapprised by the Honorable Apex Court, how they can come with a plea that there was a perjury? And if they are agreed, your lordship, the provision, no doubt they have mentioned the appropriate provision 341 of the CRPC, but the chapter is different, your lordship. So it cannot be a criminal appeal jail. Either it will be an appeal. And that too, finally, all the evidence has been appreciated, reappreciated, cross-examination, everything has been reappreciated by this court, by the Apex Court. And now they are come with a plea that there was a perjury. And that too, that complaint was dismissed by the learned trial court, your lordship. The order is perhaps they have annexed, which is not the part of my record, your lordship. They have not provided me the order of the trial court, your lordship. The finding of the trial court was absolutely correct, your lordship.
Please, let the appellant be present.
Yes, your lordship. Then your lordship may direct to appoint a legal aid counsel because it's preferred from the jail.
None appears on behalf of the appellant. However, Mr. T. the learned additional PP is present. It has come here, okay, earlier. Who appeared for the appellant?
Your lordship, it's a jail. Your lordship, it has been filed through jail. That is what your lordship I have pointed out. It cannot be a jail appeal because your lordship will see the provision, your lordship. It's in 341. So even if the legal aid counsel has been provided, that legal aid counsel will directly represent the accused.
No, so yeah, so in the last occasion also it has been observed.
Regarding maintainability, Your Lordship.
Rising out, no. This cannot be the jail appeal. Your submission it
Yes,
has
Your Lordship.
already been recorded. So now, how, according to you, it should be registered as
Criminal appeal jail.
criminal appeal?
Criminal appeal. Yeah, it should be, Your Lordship, criminal appeal or the appeal actually. It should be
No, but it was registered based on the, see,
Your Lordship will kindly come to the provision, Your Lordship, and the chapter. Now here we need to take the aid of the chapter, Your Lordship.
provision.
Provision, Your Lordship, for jail appeal is
this
383.
CRPC.
Yes, Your Lordship.
CRPC.
CRPC 383. And it's under chapter 29.
300?
383, Your Lordship. 383. Procedure when appellant in jail. In the appellant is in jail, he may present his petition of appeal and the copies accompany the same to the officer in charge of the jail who shall thereupon forward such petition and
383.
383, yes. 383.
Duty.
383, my lord. Procedure when appellant in jail.
No, 383.
Yes.
For High Court to exercise continuous superintendent over. No.
Well, perhaps
BNSS building. CRPC.
well, in CRPC, Your Lordship,
Just a
383.
minute, just a minute. It's a wrong section. Just a minute.
My lord.
Yes.
It says procedure when appellant in jail. If the appellant is in jail, he may present his petition of appeal and the copies accompany the same to the officer in charge of jail, who shall thereupon forward such petition and copies to the proper appellate court. Now, Your Lordship may kindly come to the chapter. This chapter deal with appeals in chapter 29. So far as jail appeal is concerned, it comes under the chapter 29, where not only the jail appeal, Your Lordship, appeal against conviction, appeal against acquittal, that is after finality. Now, Your Lordship may come to section 340. My lord. Yeah, chapter 26. Provisions as to
chapter
26, my lord.
340.
Yes, this is the procedure. Procedure in case mentioned in section 195. That is, Your Lordship, the provision is to offense affecting the administration. Shall not be subject to revision. Now, it is specifically section 341 deal with this matter, Your Lordship. Here, because the application under section 340 was dismissed
Section 353 is up to 2 years or fine. My lord, the brief fact of the case is that on 13/2/2023, the petitioner number 1 requested petitioner number 2 to remove the remaining materials from entry gate of petitioner number 1 quarter at NEPCO Daimo. As it was
Just a minute, let us see the FIR itself.
FIR. FIR page number. Annexure to page number 18 of my affidavit. Petition. May I read the FIR?
Okay. Yes.
With to the officer in charge police station Daimo, district Pakum Para Arunachal Pradesh, complaint against daughter of Likha Tacho for physically assaulting and inflicting grievous injuries upon me by damaging my left ear drum on dated 13/2/2023. Subject. Sir, with due respect, I beg to state that on dated 13/2/2023 at around 4:20 p.m., when I was discharging my official duty of inspection, work of newly constructed given wall behind quarter number A69 of NEPCO Permanent Colony Daimo, Papumpara District, Arunachal Pradesh, and the daughter of Likha Tacho had assaulted me and completely damaged my left eardrum and had inflicted grievous injury upon my left eardrum. That after incident, I immediately rushed to private clinic of Dr. Bomar Kamdak at Daimo, wherein he has advised me to get treated by ENT
Thereafter,
specialist.
what happened? Just a minute. Thereafter, there is a counter complaint also.
Yes, counter complaint dated 25/2/2023. This was registered by the police.
15/2, and then this counter complaint is posed on.
Not registered by police.
25/2.
Yes. Now, my lord, here, as per the FIRs, his left, as per the FIRs, left eardrum had inflicted grievous injury. But here is the, my lord, page number. Medical report of page number. Medical report is simple injury, my lord. There is no any grievous injury is caused.
She says that she was on duty, performing duty.
No, my lord, actually fact of the case is that the petitioner number 1 is staying in quarter A69. Then
So thereafter, charge sheet filed.
yes, charge sheet filed. Now,
What is the status?
now trial is not commenced. Not
It is pending before the.
CGM UPA. CGM UPA, Lanet CGM UPA.
Charge framed or not?
No, appearance stage.
When the case was charged sheeted?
Charge sheeted on the date 14/9/2023.
Let us see, where is the charge sheet? Okay.
.27 of my petition. Charge sheet.
Charge sheeted on which date you said?
That
Which month?
charge sheet on the date. No, not charge sheet.
24,
Yes.
September 24. Then yes, whether the record was called for?
This
Hmm?
year. This was called for.
Okay. So what is your submission?
Lordship, with regards to their dispute, there is a minor exchange of minor scuffle, Lordship, and which they have already settled their dispute. But I doubt, Lordship, the signature in the FIR and the settlement deed, which is not headed, Lordship, on care Perjural, Lordship, FIR of the FIR of the petitioner number 2 in FIR, may I take you to the page number, Lordship?
Then let the party be present in person.
Yes, Lordship. I thought in Annexure 2, Lordship, page number 18, signature is different, Lordship, with
Different.
regard to their settlement, Lordship.
Let the party be present in person. If they are ready, we'll
Yes.
pass order. Okay,
Yes, Lordship.
just a minute. Thank you.
Page number 18 and page number 53, Lordship.
Just reasonable.
City. Para.
No, my lord.
Last para, my lord.
Because under the circumstances, and this is city case, so on the consensus, it can be settled. 40%. Consortium, funeral, all 15,000, yes. But thereafter also, I think, okay, 15,000. It's given there as per the Supreme Court judgment.
It's a landmark judgment, my lord, superseding all the earlier judgment.
So this 1 lakh will go, 20 will become 15, and 10 will become 15.
Yes.
And the grand total will change. And then the interest, how much it is given here? Interest. As per Pranasati. Mr. Dekka.
Interest not mentioned, my lord, here.
Okay, so
Reasonable
you are basing on
9, my lord. 9%.
It is 9.
9%.
So unless you show that
It is the normal interest which is to be given. It will remain 9 only.
Yes, Supreme Court also in different.
That is why I'm asking where.
Well, for that judgment, at this moment, I cannot submit.
Then it will remain as 9 only.
For the interest of justice, my lord, it may be reduced to 7 because it's
Why?
a reasonable
We do not,
interest.
why? We do not know. It may be 9. You have to show that as per this judgment, as per
Sometimes
this-
more than 9 also, sometimes more than 9, or sometimes less than 9 also. So I'm very much
but
puzzled.
interest 7 is reasonable. 7% is reasonable interest.
No, my lord, when debt,
Do you have the
debt exercise, no, my lord, debt, when the debt authority, my lord, liberty has been exercised by trial court, my lord, without any reason, my lord, will not exercise, look into
No,
those
where is the
aspects.
reason given?
No, my lord, it is accepted on the part applicant, in some case 9%, some case even 10%, my lord.
That is why I'm saying, any one of you just show me.
No, my lord, I am not saying, my lord, I can.
You show me the 9%. You
I-
show me the below 9%. I'll pass order according to, I do not know what is the bank interest, what
My lord,
what the decision of the Supreme.
I may be given.
My humble
more-
submission, my lord. Once, my lord, that has,
But according, I know that it is normally 7%,
Yes,
6, 7,
my lord.
or at the most 7.5%.
My lord is right.
7.5%.
Yes, my lord is right.
even 9, my lord. Now, when
9, I
until,
haven't seen. 9, I haven't seen.
until and unless, my lord, the applicant, my lord, so any perversity, my lord, only in this percentage, my lord will not exercise this jurisdiction, my lord, will appellate jurisdiction, my lord. First, he needs to show, my lord, this is against the law, this is 9% is not in part of the law, my lord.
No, even if this court settle also, but
I have
if they are
ample
insurance
judgment.
company, they will go again beyond that also. Interest, we cannot go beyond. If you show me that it's 9% can also be given, so based on that, this can be. But then, as we know, that is 7.5%.
No, my lord.
Somewhere 9 may also be, but that probably was superseded. Earlier 9% was also happened,
Yes,
it
yes.
was given,
Yes.
I know. But then that was probably
9%,
later on it
7%.
was settled.
At best, 7.5 also. That is Supreme Court has. I have any judgment.
That's why, my lord,
but
simply
right now-
submission.
You could have brought.
Yes.
Submission will not,
Sorry,
my
my
lord.
lord.
My humble submission, my lord. He has challenged this 9%, my lord. Now he need to show, my lord, this is not in terms of the law, my lord.
That-
Until and
that-
that is so, my lord, how my lord will exercise in his favor, my lord. Only on mere submission, my lord.
It is to be counted from which date?
From the date of filing the
Filing.
claim petition.
Okay, then it's
Yes.
good.
We are ready to pay, but only reasonable.
The daughter is the mother and who are the
Mother,
dependent?
mother,
and father.
Mother and father, 50 each.
Yes.
50% each.
Oh, though there was 5
Okay,
claim in
so-
my lord, only 2 was given, my lord.
Okay. then
Mother and father only.
Accordingly, I'll modify. You
Yes.
just the latest. Then you take it that this one loss of life and pain will go
Yes.
away. Okay, and it's 20 loss of love and affection. 20 will become 15.
Yes, fine.
Okay, and then the loss of estate.
It will
10
become
will
15.
become 10 will increase to 15.
Yes.
And then the interest will be 7.5. Okay,
My lord.
so I'll pass order.
It would be reasonable, my lord.
Interest, my lord, I have objection, my lord.
Hmm?
Then my lord, you kindly record my objection on the reduction of interest, my lord. Right.
What is the value? You come into the what is the value if I
My lord, now
Agree.
he has made a prayer for reduction of the interest, my lord.
then no then
And
what
my
you
lord, you
do,
kindly record
then
my
what you
rejection,
do,
my lord.
you produce one judgment. Okay, latest judgment showing 7.5
My-
or whatever.
Yes.
Okay, and you also try to find out.
My lord,
We'll get it listed day after tomorrow again if you have anything.
my lord.
Okay, get it listed day after tomorrow.
Yes.
Thereafter I'll pass over.
Ready,
If there is any.
Right.
And in the meantime, you just this table showing the present changed.
Yes.
Okay, changed. So
this table also, and along with the calculation, you just bring in one sheet,
Okay.
will incorporate, okay? And at and both will bring the, I know, but then it's always better that both, so, okay, both of you. So, okay, had Mr. Deka, Land Council for the appellant. Also had Mr. Lee L. Parvin, Land Council appearing on behalf of the respondent claimant, staff. List this on the request of both the party. List this matter again on Friday as a part heard matter. Okay.
Yes.
Objection. Yes. Okay, just a minute. Huh? Yes. Yes.
This is an appeal against conviction. This case, I have been convicted to undergo RI for 10 years under Section 4 of the POCSO Act.
10 years.
10 years.